have Member Green, Member Morris, Member Gale, and Member Miller. Four members? Yes, we have 4 members online. All right, so for today's sitting, it's a continuation of the review of the matrix clause by clause.
Member Miller is present.
And we
Good
will
morning, everyone.
Good morning. And for those online, please remember, if you are speaking, to just turn on your cameras. So this sitting is a continuation of the review of the matrix, clause by clause. We will resume at clause 24, page 13, but I know that as minuted, there are a number of issues, questions that were raised for which we will need our technical persons to respond. And so I welcome you this morning to the continuation of this meeting, and we will go through the confirmation of the minutes, because in there was captured the many issues with which we grappled at the last meeting and for which our technical or legal persons may have some updates. So let us take the minutes, and as we go through, we can highlight those areas for which there needs to be an update. And we can take that in, I guess, matters arising from the minutes. So we'll begin with page 1. Page 2. In the very first paragraph, second sentence, where it reads, she stated that the new clause, subclause 2422 is incomplete. Not sure what needs to be said there to complete that. Yeah. And also, where it says she indicated that a new subclause would be inserted to include a penalty for the employer, I was simply reading, I was reading from the recommendation, I think, of the JTA at the time, so it was not the chairman indicating that it would be inserted. So could I ask for a review of what's written here as clause 24, because it's written as if it's a done deal about the penalty for the employer, and it was simply a restating of what was recommended, which we went on to discussing, and I think we haven't arrived at a position on that yet, because there were some knotty issues, considering that government is the major employer of teachers. I'm at the very beginning, on where it says clause 24. Look at the top where it says clause 24. Well, about the middle of the page. I'm asking for that to be reviewed, because it's written as if those were recommendations made rather than just a restatement of a recommendation from the... All of what's written there. Yeah. Let's move on to page 3. We'll move on to page 4. Page 5. Page 6. Page 7. And finally, page 8. I'm going to ask for confirmation of the minutes, and then we'll take the matters arising from the minutes. So moved. Yes.
Here.
All right. Go ahead, Member Gale.
I was saying I'm seconding
All right.
the approval of the minutes.
All right. Matters arising from the minutes. Because these matters arising will dovetail with the updates that we would like to get from our legal team. Ms. Shoreland, would you like to begin? There were a number of issues raised at the last meeting, and we can take them in order of the minutes, or if you have them in a different order, that's okay. I remember we all wanted to know if para-tutors would be included in paraprofessionals. That was one thing. But you can take them in maybe the order of significance, if you would like to.
Good morning, Minister. Good morning, everyone. Sir, Mr. Lambert, good morning. We have done some research, Minister, as we agreed last meeting. But owing to the Jamaica, the World Teachers Day, we have not had enough of time together to consolidate the information that we have already researched. So we are asking you kindly if we could leave part 4 and go on to part 5, and then in the next meeting we would have consolidated the research that we have, because we have done the research, we have just not gotten together to discuss the findings and how it will apply to the changes that we would like to make. Thank you, Minister.
Minister, Chair.
Yes, please go ahead, Member Gale.
Yeah, I am in support of that, because we would have learned in this space, in even other joint select committee meetings, where the technical team would have done the research, but have not had the time to have a coordinated approach in terms of consulting among themselves. And I would agree that we need to give them the time to be able to consult among themselves so that they can agree, and when they represent it to us, it is clear and in one voice. So I'm in agreement with that approach to give them some time.
All right. Committee members? All right, we'll allow our legal team and technical team some more time to go through all the issues that were raised in the last meeting, and you can use the minutes as a guide, right, to refresh your memory as to what those are, and then we'll expect that in the next meeting we can come back and we can wrap up this particular part of section 24.
Minister, through you, even though we have not consolidated all our thoughts, perhaps we can say a few words which will assist the members to consider as well for our next meeting. I just want to draw our attention to the issue that was raised regarding whether the word teach should be substituted for the term practice as a teacher. And just to say that practice as a teacher is used in sections 7.1k, 22.4, 24.1, 28.1b2, 60, subsection 3 and 81.1b, and paragraph 11c of the 4th schedule of the bill. And on a cursory or initial reading of those provisions, it seems as if practice as a teacher could be substituted, or teach could be substituted for practice as a teacher. However, Dr. Gordon and her team need to examine these provisions and this term, practice as a teacher, to see whether it's a term of art that is critical to the bill. It is a term which is used generally in education circles and to determine whether we can't do without that term. So that's one. In relation to
Could I ask before you move on?
Yes, Minister.
Could practice as a teacher be included in the definition of teach then?
Perhaps that's an idea too. As it is now, it is defined in relation to clause 4. So I don't know if we could incorporate it in the definition of teach. Perhaps that's an idea too, Minister. So that we could add that as something to examine. Right. In relation to the recommendation or the idea raised by Member Brown and other members in relation to having a tier approach to dealing with clause 24, I just want to read the penalty, the substituted penalty provision, the penalty provision that would be substituted for, I think it is 24.1.2, that would create a tier of offenses. So it could read, a person who contravenes subsection 2 commits an offense and is liable on summary conviction in a parish court, A, in the case of a first offense, to a fine not exceeding whatever we decide, what is $200,000, so in the first instance, or whatever the committee decides, and B, in the case of a second or subsequent offense, to a fine not exceeding $500,000 or whatever the committee decides is appropriate. So that's for consideration of the members to determine whether that is that is the approach that they want to take in relation to the recommendation of having tiers. In relation to the definition of paraprofessional, we have to consider whether the paraprofessional should be defined, including the person specified in paragraph B of the definition of teach. And in that paragraph, it talks about assistant teacher, teacher's aide, and that sort of thing. Should we, in defining paraprofessional, say includes, which would leave it open to add other persons, or should we say means and then have a set list of persons who are considered paraprofessionals? So that is what we have so far, Minister and members, for us to continue to consider and to come with a more fulsome answer to these questions on the next occasion.
Thank you so much. Was the team able to look at the other professions for their fees, their levels of fees, here in Jamaica as well? Well, primarily here in Jamaica.
Good morning, Chair and members. We were able to do some research in terms of the other professions, not for other jurisdictions as yet. However, for the other professions, so far the research did not reveal any penalty for practicing without a license. They only had provisions in relation to fraud, but not for practicing without a license. The only profession that we saw in relation to practicing without a license is the Legal Profession Act, and that does not penalize an attorney for practicing without a license. What it does, it has a provision where it allows the attorney to give the attorney time to pay the practicing fee in order to get the certificate, and failing that, they will be guilty of professional misconduct. So it's not a situation where the attorney is penalized. It's not a criminal offense. Well, they are penalized, but it's not a criminal offense. So if they are practicing without the certificate, then they will be guilty of professional misconduct.
Here, can I ask a question, just for clarity? Chair?
Please go ahead, member.
So in the approach for professional misconduct, is there an imposed sanction?
They will be subject to disciplinary proceedings.
So herein lies the situation, Chair, because we're making a distinction between, as we would have argued, what would have constituted a fraudulent act, as opposed to someone who may have missed the deadline or would have been operating without the license. And we're seeking to impose some sort of a penalty. Now, I'm of the view that given the discussions that would have represented itself, the committee would have wanted to make a clear distinction between what would be a penalty of an offense in relation to a conviction as opposed to a disciplinary penalty. And I believe we ought to contemplate approaching it with making a clear distinction between a conviction for the fraudulent and disciplinary action as associated with other professions. I can recall in another committee meeting, I think the one dealing with tobacco, we are grappling around the same type of approach. And the challenge that I have is where if we have other professions that don't impose criminal offense, in this case, we have to consider making the distinction. Thanks, Chair.
I'm sorry, Member Brown, your mic isn't coming through clearly.
Yeah, the question is whether or not the offense would be committed by not renewing the license or failure to pay the fee. So, as in the case of the lawyers not paying the prescribed fees to register, renew their practicing certificate, is that the same thing we're looking at here?
So,
Sorry.
I'm sorry, Member Green, you wanted to come in? Because I was going to call on you because I remember at the last meeting, yes.
I wanted to come in, but I hear counsel is going to answer, and I'm actually en route to the parliament. I decided to join you in person. So let me hear what counsel has to say, and if I have to intervene before I get there.
All right, go ahead, counsel.
Well, for the legal profession, the fee has to be paid in order to get the certificate. So it's the same thing in terms of renewal, in my opinion, in terms of someone paying the necessary fees to get their license to continue to practice as a teacher. So
let me just add on that, counsel, and I'm not sure. It was in and out when Member Brown was asking the question. But the offense does not come with not paying or not renewing. The offense comes with the going to practice teaching without having a license. So again, akin to the legal profession, right? You can decide not to renew your legal certificate. So you can decide that you're not going to pay the fees and you're not going to get a new practicing certificate. But what that means is that you can
We're not hearing you, Member Green.
practice as a lawyer, right? Sorry, there'll be no offense if you just do not pay the fees.
Through you, Chair, I agree with you on that. But what if the lawyers
or if you do not renew the license? But
what if the lawyers?
Hold on, Member Brown. Let Member Green finish his thought, please. Yeah. Go ahead, Member Green.
So sorry. So if you go into the classroom not having renewed your license, that is where the offense is created, and not just going to the classroom if you practice the act of teaching in accordance with the bill without renewing your license. That's when the offense comes in. But the offense does not come in if you decide that you're not going to renew your license or you decide you're not going to pay your fees.
I'm sure you mean. I'm saying I agree with you on that. But what if the lawyer is engaged in some conveyance thing or some advice to people or even to turn up in court? What is the penalty there?
So if you turn up in court and you are not you do not have a practicing certificate. You know, I would have to refresh my memory of the law, but I think it's a criminal offense.
Minister, if I may, let me just read for the benefit of the members. Under the Legal Profession Act, it says where the council, this is subsection 3A of section B, section 5, sorry. It says where the council is satisfied that a person is practicing in contravention of subsection 2, the council shall in writing direct the person, A, where the prescribed fee has not been paid, to pay the prescribed fee within a specified time. I will read what subsection 2 states that an attorney would be in contravention. Subsection 2 says, subject to section 7, a person shall not practice as a lawyer except by virtue of and in accordance with a practicing certificate issued under subsection 3. So based on the provision, once you are practicing without a practicing certificate, you will be guilty of professional misconduct. Thank you.
Is there a fine for that? Or what's the penalty?
As indicated earlier, Minister, it's not a criminal offense, but you'll be subject to, based on the fact that it's professional misconduct, then disciplinary proceedings can be brought against you.
And disciplinary proceedings can be the form of a suspension.
Counsel?
Well, it depends on what the committee decides whenever the disciplinary action is taken, which I think, if my memory serves me, I would have to look back at the regulations where that is concerned in terms of whether it will include a suspension.
Or through the chair, it could go up to being struck off, because a range of penalties, depending on, as you say, what the how severe the committee feels about it. So the key thing to us, concerned to me, is that it's not a criminal offense, and it is for us to consider whether or not the teaching council should have similar powers of discipline and to move away from it being a criminal offense.
Go ahead, Dr.
The one though Senator Brown with fraud is very clear, because fraud assumes that you say you have a license and you are registered and you don't.
Right.
And that's what the fraudulent.
Right. I think we're agreed on that, and that is in a different category by itself. What we are discussing is one, renewal of the license, and there's been a decision by the teacher, advertently or inadvertently, not to renew, but the teacher continues to teach. That's what we're grappling with right now. Go ahead, Dr. Gordon.
Thank you, Minister. As we have this discussion, it is important for us to keep in mind that the legal profession is client-driven. The teaching profession, the clients are provided. And there goes the difference when we make decisions regarding the teaching profession. The clients are provided by government. If a teacher is a bad teacher, the teacher still has clients. If a lawyer is a bad lawyer, clients can go away. So in this discussion, it is important to consider the difference between the two professions. This is one of the reasons why I said let us spend some more time on it as a technical team and discuss the consequences of the decisions. Thank you. Thank you, Chair.
All right. Thank you, Dr. Gordon. We will allow the technical and legal team to do some more deliberations on this and come back to us on these points.
Chair, before we move on, what was the team able to get information on the Nigerian legislation that
Were you
We
able
have the
to get,
information on Nigeria.
Member Brown, can you
We
repeat?
have
Okay.
information on Scotland. We have information on Wales. We just need to discuss the information that we have. We have done some research on Australia and some on New Zealand.
my question is be answered. The issue is at what point will this be shared with the committee members? And could I suggest also, Minister, that the points that Mrs. Sherland made earlier, if that could be circulated by the Secretary she wanted to alert us to some thinking, and if those could be circulated to the members prior to the next meeting.
Those will be captured in the minutes, Member Brown, and the minutes go out pretty quickly after the meeting. Yeah, that's right.
I'm sure my friend has it down there, so she could share with Mr. Nash and he could circulate it.
All right. Member Brown, Member Green, you're here in person. Before we move on, is there an intervention that you have? Any further intervention?
Hear me now? Yes. Yeah, so just to say, Chair, I think I came in on the point that was being made about vulnerability of the grouping that teachers serve. And, it's something that has to weigh heavily in our minds when we consider these provisions. The reality is that teachers are put in front of our most vulnerable members of society, in children. So in thinking about the standard that we will hold somebody who says they're a teacher too, we have to always think about the children that they serve and not necessarily just the individual who is the teacher, right? What we're saying is that if you are going to say that you are a teacher and you're going to go into classrooms and help mold the minds of our youngest, then this is the standard that we want you to adhere to. So I think as we go through the various clauses as a parliament and as a country, we always have to reflect what are the standards that we want people who are in our classroom to uphold, and how high of a standard do we need to set for that.
All right, thank you, Member Green. Any other interventions before we move on? Okay. All right, we'll continue. On section 25, and this is the section that deals with the offense of pretending to be a registered teacher, licensed teacher, or instructor. And I think we would have had some overlapping discussion in the other section, but this is the one that actually deals with that offense. So we have recommendations from two different groups, the Jamaica Teachers Association and the Teachers Colleges of Jamaica. And I believe it's the same as we've seen in the other sections, and whereas their recommendation is that they understand the rationale of deterrence, and the fines of up to $500,000 are too harsh and excessive. At the very least, teaching without a license or pretending to have a license should not be treated equally with the situation where a person acts fraudulently or is found to have made a misrepresentation as it is proposed in the bill. And I believe that we have sufficiently ventilated that, And we are of the same mind that it should be treated separately, where you commit the offense of pretending to be a registered teacher, licensed teacher, or instructor. So if we all agree, we could move on from there. Members? All right, the JTA also proposed that.
This is where the benefit of the Nigerian and the others would be helpful to us, because as the Teachers Council, teachers' colleges propose that we look at that model, the Nigeria model, in our approaches. So I'd urge, while my mind at this point is for criminal sanction, I'd love to see how others treat this. And so we have Wales, Scotland, at least to look at and to see where we come down in the end. So the general thought have been tough on this one, but is there another approach that can be adopted? I at least want to see that.
Thank you, Member Brown. Also, question to the legal team: was this the part that you also wanted to defer until next week? Section 25. Ms. Sherland, was this also the part you had asked to be deferred as well? All right. All right, then we'll move on to section 26. Looks like 26 is still the same. Offenses involving fraud and misrepresentation. Yeah, that is part of that. 26 is also part of it. So we'll defer. Section 27, it's eligibility for registration as a teacher. And we have a recommendation from the University of the West Indies School of Education, which says in relation to section 27 and 29, the metrics used to determine, in quotes, has the English language skills in this subsection were considered very subjective and required further clarification. So if we move to section 27, C, 27C. Section 27 lists a number of eligibility requirements for registration, and the University of the West Indies School of Education is querying 27C. That requires a person who is eligible to be registered as a teacher to have the English language skills, both written and oral, prescribed as suitable for registration as a teacher. Dr. Gordon, members of the team, go ahead.
Thank you, Minister. I note this. However, the education system operates in English so far, and therefore a teacher should have or must have the English language skills necessary to conduct lessons in English language in our schools, in our institutions, because that is the language of the education system.
Chairman, I agree. I agree wholeheartedly. There are certain prerequisites for certain jobs. It so happens that in education and in teaching profession, as stated, English language is our standard language. It goes without saying.
Okay, I didn't understand why they said it was considered very subjective. and required further clarification.
Is there, through your chair, is there a requirement, for example, which says that every teacher must have a CX, whatever the exam's name now, CSEC pass in English language? Must they have a university? In other words, how does this fit into the debate about patois? And I think that's what is behind this view about it being subjective. I'm not opposed to it, but is there a standard that the people must have?
To enter Teachers College, the person should have had a pass, CXC pass, at level 3 at least, in English language, to enter the Teachers College.
So that's the intent?
Yes,
is there a minimum?
It's stated a requirement for entry to Teachers College.
But is it that, I'm just trying to interpret here, is it that the University of the West Indies School of Education is asking for a minimum level to be described here then? Because it simply says, has the English language skills, both written and oral. There probably should be an objective measurement, I don't know. Maybe that's what they're referring to when they talk about the subjectivity of this. Because, I mean, I believe everybody in Jamaica is going to say they have English language skills. But isn't there an objective, professional way of measuring that?
Not at this time, Minister, but there is this dialogue that we need to have an English language standard for the profession. Reason being that people have questioned the level of English language competencies of some of our teachers. So a dialogue started, but there's no decision. We have not arrived at a conclusion as to what that professional standard or the standard of competencies should be.
Minister?
Go ahead, Member Rodriguez.
Do you? Yes, I'm just thinking that there is something that we probably are missing. And I think the comments just made have confirmed that in my mind. Because I am under the assumption that there would have been a basic requirement to enter the teaching profession, basic requirement for English, being able to speak, write, and understand, communicate in the language. But it seems as though there are some internal, and by internal I mean within the teaching profession, some discussions as to what level of English is accepted. Now, to me, this is a separate matter from the debate as to whether or not we should teach in patois, etc. To me, that's a completely separate debate. As of today, we use English as our primary language. And as such, persons who are in the profession should be able to function fully in it. And I think if we use the requirements, and if we know whether or not the requirements for entry to Teachers College are actually being utilized properly, and we're not giving a bly or any such thing, then we should be fine. However, if the rules that were just mentioned for our basic requirement, for our basic entry requirements are not being met, then we need to put something specific here. So I think that's where the issue is, but also we just need to confirm what that discussion is that's been happening either with the schools of education, the teachers' colleges, the JTA, and the ministry in terms of English as the language that we use to teach, and the requirements for teachers specifically to be in the classroom with our children.
Thank you, Minister, if I may. The words in the bill say, has the English language skills, both written and oral, prescribed as suitable. So perhaps the solution could be that we make some kind of amendment in the education regulations or the regulations under this act, or this proposed act, to specify what those requirements are in relation to the English language. Because it says prescribed, so we can use that now to make an amendment, an appropriate amendment. And when the ministry has settled on what are those English language skills that are appropriate for someone who will be entering into the profession.
Just so I'm clear, Ms. Sherlin, you're saying that one way of doing this is to make an amendment in the education regulation to specify those requirements, or what was the other way?
No, Minister, when we use the word prescribed, we mean either prescribed in the current act that we are dealing with or prescribed by regulations under the act. So if the ministry can decide what is the appropriate English language skills that persons should have, then this could be specified in legislation. Even in relation to this, if it is settled, we could make a consequential amendment to the education regulations, for example, if that is appropriate, and put it in the schedule where we have that list of amendments to various pieces of legislation which touch and concern this bill.
Go ahead, Member Green.
If we say as prescribed, as suitable by the council, wouldn't that be sufficient?
But that still leaves it in the subjective realm, right?
It's subjective, but you indicate who will prescribe the suitability.
Right.
In other words, I'm not sure. It's very hard to put specifics in relation to, I guess.
At least you have exams, right? There should be a minimum in terms of the subject area demonstrated through exams.
Yes. It's one of those issues that is not free from conflict, Minister. I think that's why it was so wide, but it has to be narrowed, right? I was wondering if by indicating clearly who would do the prescription, if that would be sufficient narrowing, so that the council would have to put forward what it indicates are sufficient English skills. That wouldn't be in the law, but the law already says that you have to have sufficient English skills prescribed by council. And then the council, at a time that they would have to prescribe what are those English skills. Am I thinking out loud?
According to Dr. Gordon just now, we do have a minimum level that a person has to have to enter into a teacher's college. So we can't go any lower than that to enter into the profession. Dr. Gordon?
The challenge we have had, Minister, is that the exit standard, we have a minimum entry level. But when the teachers graduate from the colleges, we have no national standard for English language. And that is a dialogue we have had with the colleges, that there needs to be some modality or way of establishing the graduate standard. When a teacher leaves the teacher's college, what should be the competencies that we expect that teacher to have? That is the common standard that we are looking for, and we have started the dialogue. Member Green made a very important statement: who's responsible to prescribe? And at this point, we are ourselves not clear, because the UCJ, the University Council of Jamaica, is the body that works with the colleges on their programs. So it's this decision that we need to make.
So, sorry, go ahead. To you, Minister. I don't think we have a disagreement on the standard. I think the problem is the language of the clause that need to be tweaked to reflect the fact that there's a minimum prescribed. But just how it is written here as the English language skills. So if you just tweak the clause to say achieving a minimum level as prescribed for suitable as a teacher. Much of what is here beyond the brackets. Just tweak the language is what I'm proposing.
Well, Member Brown, what I hear from Dr. Gordon is that there is no exit level for English at the college, right? There's no exit standard at the college.
Minister,
yeah.
In addition, Minister, we're forgetting that there may be persons who come to Jamaica to teach. So all our conversation thus far has been around those who have attended our teachers' colleges, but what of international persons, especially those who may not have English as their first language?
Actually, Minister, please, they have a standard. For the Spanish-speaking teachers, when they come to Jamaica, there's a minimum standard of English that they must know.
No, I'm not just talking about those who speak, who are here to teach a foreign language. I'm also referring, let's just say, for example, someone's husband is coming to Jamaica as a diplomat and they're a teacher and they manage to, through the teaching council, they get accredited to teach in Jamaica. So they're going to teach geography. In high school, I had a biology teacher from India. And what I'm saying is we have to, when we rephrase this section or whatever decision we take about this section, have to keep in mind that we will end up at points with teachers whose language is not first, is not English, and they're not in the country to teach a foreign language.
Right.
So we just have to
even
keep that in mind.
Even so, member, there has to be a minimum level of English, or else the children will not understand. That's what I'm saying, Minister, and it can't be based on entry or exit to teachers' college. Sure. There has to be something else, because those persons would not have gone either in or out of our teachers' colleges. So we have to ensure that whatever way we phrase this section keeps that in mind as well. Okay, but are we making this?
So Chair, I would go back to some of the things I said before and to the intervention that was made directly before me in relation to there would be avenues for which, once you decide on a standard, you could make various amendments. And I think that was the point that was made that I probably glossed over. Because, you know, reading the section, I think it's sufficient, quite frankly. I don't think you can go any tighter with the section, right? Because it does say has the English language skills, both written and oral, prescribed as suitable for registration as a teacher. So it already indicates that whoever registers as a teacher will have to prescribe what is suitable. And I think Member Rodriguez made a good point. Suitability will vary based on the circumstances, because if you're coming from a foreign country because we need teachers who their native language is Spanish, there's a minimum standard that they will have to ascribe to as separate from a minimum standard right across the board. So I believe the provision is clear, which is important, and is enough to capture what we're trying to do. And if there are any standards that are prescribed, changes can be made, as was being said earlier, to like the Education Act, things of that nature, to define a minimum standard. But I would leave it as is, Chair. That's my submission.
Dr. Gordon? Legal?
Minister?
Go ahead, Member Rodriguez.
I would agree with Minister Green, and the section as written in my mind is also clear. I think what needs to happen is the other supporting legislation or entities need to have those rules sorted so that this points to this prescription exists that we're talking about in this legislation. I think that's where the emphasis, so maybe go back to what I think Ms. Gordon had said, where the Education Act or regulations, I can't remember exactly what she said, needs to then be adjusted to respond to this that we're putting in this bill.
All right, maybe the issue I have with that is knowing where we are with the education regulation or the Education Act right now. It may take some time to get that amendment. Okay, sorry, go ahead, Ms. Anastasia.
Minister, what we were discussing is the regulations, the prescription would be for the regulations in relation to this piece of legislation.
All right. Okay, good. All right, so if I can summarize then, we're saying leave the language as is, and whatever to be prescribed would be prescribed in the regulations for this bill. That's correct? All right. All right, members?
Before you leave 27 minutes now, 27E, it addresses as to be qualified, counsel has to be satisfied person of Jamaican has a permanent resident status. I'm assuming you're talking foreigners here now. And holds a valid work permit. Again, it sounds to me like a foreigner. So it's the language here that can we tighten it up? You probably will have a Jamaican in one here at E, and then we have a new F, a foreigner who has permanent status or work permit.
E is saying you can be a Jamaican citizen, you can have a permanent resident status, which is different, you can hold a valid work permit, which is the third. So wouldn't that cover everyone?
And I'm saying just if we separate, if we put, because what we've done is lump the Jamaicans and foreigners.
So you want that separated
That's
out.
what I'm saying.
So you want a section
a Jamaican
that says
resident
is a Jamaican citizen.
Yeah.
And then you go on to
yeah.
to name in the other categories.
And how does this affect Commonwealth citizens, for example, who may not need, well, you have to be a permanent resident, maybe, yeah.
Any objection from legal persons just to separate out Jamaican versus? Okay. All right. We'll move on to the comments from the University of Technology. And they also raised some comments about section 27, much longer. So retirement and licensure. It says the Act stipulates a lower age limit for licensing as 18 years, but not specify an upper age limit. The question is whether there is an upper age limit at which the licensure will cease, and whether a teacher's authorization to teach ceases at retirement, even if that teacher's 5 years license might not have expired. Also, that we further question if there's any consideration for critical shortage waiver to allow for the continued licensing and employment of a teacher beyond the year of retirement, or the recall of a teacher who has already been retired. And I think the response from our legal team is that there's no upper age limit. Retired teachers, once in practice, public or private, has to pay reduced license fee. This assures that the practicing teacher maintains currency. Could you elaborate, please, technical persons?
Thank you, Chair. The teaching profession has no official age limit, none that I know of, as long as the person demonstrates the capability to teach. And in our case, the person would have been licensed, because the licensing procedures will allow retired teachers to maintain their teaching licenses as long as they satisfy fit and proper to teach.
Through your chair, is there a retirement age in the education system?
There is a retirement age from the formal employment. But practicing age, I don't know of any place in the world that there is an age set for a teacher to practice, as long as the teacher satisfies the requirement of fit and proper to teach. Just recently, there was one article from the United States where a teacher, 93 or 96 years old, I don't remember, I don't recall, was allowed to teach. She was teaching and she was doing an excellent job. So as far as I know, the formal employment, there's a retirement age. You retire from formal employment. But the ability to practice, there's no age limit on it.
I just seek some clarification there. So you're making a distinction between being employed to teach in a school, for example, a government school, versus being able to act as a tutor? So you have to retire from the school system as run by the Ministry of Education, but you can still teach. So a private school can hire you, or you can have, you can be tutoring. Is that the distinction?
Yes, you hold your license. Once the teacher has a license to teach, and the license is evidence of practice, of currency in practice, and the teacher is able to conduct practice as a fit and proper person to teach, the profession has no age limit, not the teaching profession. I don't know of any place that it has an age limit.
Member Rodriguez, are you okay with that response?
Yes, I am. I just wanted clarity and I've gotten it. Thank you so much.
All right, wonderful. As well, the University of Technology spoke to the section 27C in terms of the English language. They note that with concern that the Act insists that teachers be competent and certified in the use of English language, and this is endorsed since Standard Jamaican English is the official language of Jamaica and is the received language across the curriculum. However, the absence of an official language policy in the Ministry of Education invites a questioning of the basis on which the Act insists on the centrality of English in the Jamaican education sector. In addition, there is concern as to how competence in English language proficiency will be assessed. And the response, is this the response from the legal team? The response is that teachers who have gone through teaching studies would have had English skills as a requirement in training college. The regulations will treat with the issue of language skills based on arrangement with the colleges to assure standards. On the basis of evidence, the council may require national standards of English language attainment. And just to say, in terms of the questioning of the lack of policy from the ministry, we do have a draft policy that we will be rolling out in short order. We'll take it through the consultation process, and we will make that announcement when the time comes. And of course, we will be going out, having town hall meetings to make persons aware of what's in the draft policy and seeking their comments on that policy. All right, if there are no other interventions from members, we will move on to section 28, still on eligibility for a license. And we have the Teachers Colleges of Jamaica weighing in here. They would like to remove section 28B2, requiring that the applicant for a license must have practiced as a teacher in Jamaica for at least 3 consecutive years of the previous 5 years. And the response is amend period of currency to 2 consecutive years in section 28.1b2 and 28.2. This is to allow appraisal to take effect. Could we just hear from the legal persons on that? And if we read on in the comments, the Teachers Colleges of Jamaica believe that if implemented, as stated, it is likely that a court of competent jurisdiction would find Section 28B2 discriminatory against female teachers who already face grave inequalities on the basis of their gender. A teacher may find herself unable to obtain a license to practice her profession upon recovering from cancer treatment, motor vehicle wreckage, maternity leave, bereavement of a spouse or child, unemployment, mental illness, financial distress, homelessness. And I'm reading the recommendation, what would have come in from the Teachers Colleges of Jamaica in their submission. So they feel that the provision is unnecessary and should be removed. Section 28B1 requires that continuing professional development standards are met for a license to be issued. In practice, the teacher would be certified as proficient in the area and deemed knowledgeable of matters current to the profession, notwithstanding that the applicant was unemployed or outside of the classroom for a period.
Please, Chair.
Please go ahead.
We discussed this section and we generally agreed that we could reduce the period to 2 years, but we must have enough time to appraise the person. So the person would have to teach for 2 consecutive years, given time for adequate appraisal.
Chair, just to clarify, why it needs to be consecutive, and how do you treat consecutive? In some legislation, continuing as a definition. Are you insisting that it must be 2 straight years?
Yes, and I tell you
break?
why. If the person comes in to teach in a school and for 1 year, at the end of that year, you do an appraisal, which would allow the person to carry on for the consecutive year, and you do another appraisal. Now, if the person leaves the school, leaves the profession, and goes to some other place to work for another 2 years, then there's no guarantee that the competency that you identified the year before, depending on how the appraisal is set up, that the person comes back 2 years later with the level of competency that is suitable for the program and the children the person is assigned to teach. That is why the consecutive years are important.
And through you, Chair, and by consecutive, we are including the holidays. So in other words, September to June is 1 year.
Consecutive school years.
That's what needs to be clarified.
Thank you.
Could we therefore insert that, Minister, to clarify what consecutive years mean, consecutive school years?
My academic years, I think, probably is better than school years.
That's fine. That's
yes.
fine.
So that's an insertion. So we're leaving this. We're not accepting this recommendation
We were. But it's just clarifying consecutive years to be consecutive academic years. Because in the nature of the scheme, there is that break for holidays and so forth.
So we're moving to 2 years? 2 years instead of?
2 years instead of 3 years. But we
Instead
do
of 3
need the
years?
consecutive years.
2 consecutive years.
2 consecutive,
2 consecutive
years.
academic years. Okay. All right. University of Technology, their observation or concern query also relates to Section 28B. They wonder whether professional development programs and activities will come at a cost to the individual teacher or the institution to which the teacher is employed. And given the cost of some professional development programs, will this not have implication for teacher, lecturer remuneration? And the response is that the professional development program provided by the council will come at no cost to the teacher. All right, so let's move on to Section 20.
Clear. No cost to the teacher. What about the institutions? Who's going to fit the bill? Because there is a bill for that.
No cost to the individual teacher.
But the institution,
But the institution has to pay.
I see.
Okay, we'll move on to Section 29, eligibility requirements for authorization to teach. And we have a number of observations, concerns, queries, recommendations there, starting with the Jamaica Teachers Association. And they're saying it's unclear whether Section 29(2) of the bill should be read cumulatively, that is A to H, or should it be interpreted that sections B to D should be read disjunctively. The reason for this uncertainty is the use of the word or at the end of subsection B. And the response we have from our legal team is that the bill to be amended to delete or at section 29(2)B. Further, at F, it should be amended to read an authorization to teach. So we'll accept those. We'll accept that response from the legal team members. All right.
Note the word sitting chair comes in 29(1), and I just raised it against the background of the discussion we had last time about setting institutions and so forth. So just for it to be noted, and when we decide whether it's setting institutions or not, we then make the adjustment.
Right, so that's on the list of items, I believe, when the team comes back next week that we will be talking about. Teachers Colleges of Jamaica, their recommendation is to remove section 29(2)A, B, and C. And they've given a rationale.
Madam Chair?
Go ahead, Dr. Gordon.
My colleagues have reminded me that based on the earlier discussions that we had on homeschooling, we will need to have a meeting on this section. the author,
Section
Section 29,
will also need to have
the
a
earlier
meeting.
discussions we have had on homeschooling.
Okay, in terms of the proficiency in English and so on. All right.
Madam Chairman, if I may, I think one of the questions that was being asked when we were discussing was in relation to 29 2C, whether or should be placed there and at the end of D, so that if we read from subsection 2, subject to subsection 3, a person is eligible for the grant of an authorization to teach from the council if the council is satisfied that C, the person has skills that are in short supply, or the person has the knowledge, qualification, skills, or training reasonably considered by the council to be relevant to a teaching position that the person has been offered, and the person is a fit and proper person to teach. So we have to consider whether or is appropriate at C and is appropriate at D. Because if we just have and at the end of G to say that the person must have all of these, it may not be appropriate. Because in some circumstances, the person would qualify to get an authorization to teach based on the circumstances. If the skills are in short supply, or if the person has the knowledge, qualifications, and skills. So there was a question whether or and should be placed at appropriate positions here based on the the peculiar circumstances.
So we stand guided by you, the technical team, in terms of just the technicality of that language and what it means when you insert ors and ands. Member Green or legal? Yes.
I think that point is critical, Chair. I think there has to be a relook in relation to the scheme of this section, just to see. It definitely needs some and or. It definitely. What are we saying that we must be satisfied of for the authorization to be granted, and what is discretionary? You know, and I think that is important, because definitely I think you want to ensure, my reading, that firstly you try to find a licensed teacher, right? So that is the first. So you have to be satisfied that the prospective employer is unable to find a licensed teacher. So once that is done, then what else is needed in each instance? And the instances may vary. So, you know, there are instances where it's about a skills shortage, but there's also instances where you can't find a licensed teacher, but somebody has the knowledge, qualification, and skills who can be utilized, but is not a licensed teacher. As we've discussed over time, people who have significant experience, but they've never gotten some of the requisite qualifications. So I think the scheme has to be looked back at, and I think there has to be a distinction between the various instances. And well, I've already heard, because I was going to raise the point, I wasn't here when that discussion was undertaken, but I see we're moving in the direction of saying that Section 3, subsection 3, 27.3, may definitely be an overreach of the Act in relation to home education programs undertaken by parents. But the team has already said that they'll look back at it, and some strong submissions came from entities. 29.3, so the team has already said they'll look back at that, Minister.
Right. Well, okay. I agree. I agree in terms of the relook at this, taking into consideration as well what the University of Technology said in terms of, is that their response or is that the response of the legal team that we have on that page, on page 19? That's the response of the legal team? Look under University of Technology. That the legal team, Member Green, is saying the bill is to be amended to delete clause 29.3 and 4, right? A parent who proposes to instruct his child alone is not required to have an authorization to teach under the bill, but application of the Ministry of Education and Youth processes relevant to the independent schools homeschool will apply to that parent. Okay.
This is what the homeschoolers seems to be asking for, and we are. I think it was member Senator Ransford Braham who pointed us to leave well alone, and I think we are in good stead.
And Minister, I do appreciate that when it comes to children, the responsibility is not just the parent, and we've all appreciated that, because if something goes awry and the child does not get the sort of educational guidance that is needed and becomes then a call on the society, it's all of us. All of us have a problem, right? So I think based on what the team has said, they have found a middle ground. In other words, it's not a free-for-all. You can't just keep home your child and say you're going to homeschool your child. You have to have a sort of program in place. But with that said, to put a parent through an application for authorization is so I'm happy we've moved in the right direction. My bad.
Additionally, just let me add, Member Green, I had committed that at the ministry we will begin the process of creating a policy around homeschooling as was requested, as was a recommendation. I gave a commitment to that, so that is something we will develop in time. All right, so let's move on to Section 30, conditions for registration, licensing, and authorization to teach.
Minister, just to make it clear that in terms of the homeschooling, you may have two situations: a situation where the parent decides to teach his or her child, and a situation where the parent decides to employ a teacher to teach his or her child, and that person would need the necessary license or authorization to teach in a homeschool situation. That's
already in the bill, or you're saying that should be inserted
just to ensure that Member Brown is understanding.
Member Green?
No,
Member Brown, okay.
Is understanding of the application of the provision in relation to homeschooling. So it's not a situation where homeschoolers are totally free from the section. They have to, if they intend to employ a person to teach his or her child, then they will need to abide by the provisions. And also to indicate that for the same eligibility requirements, as it is now, it really contemplates a situation where the employer is a board or an institution, but it doesn't really contemplate a situation where a parent is the employer, and that is why we would need to ensure that the criteria can be met by that person as well.
So the language, through your chair, the language is going to be adjusted to address that.
All right, thank you. We'll move on to section 30. Council may impose conditions for registration, licensing, and authorization to teach. Ms. Sherlin, could you just give us a background on this and the recommendations here?
I'm sorry, Minister. Could you please repeat the question?
Right, no, we're on section 30. The council may impose conditions for registration, licensing, and authorization. And I see here that there's to be a discussion with OPC on section 34. Section 34 in relation to the condition of a teacher to report charge or conviction of an offense. Should this condition only apply to disqualifying offenses? There's a question mark there. So I just wanted some explanation on that and for us to move on into the recommendations coming from the Teachers Colleges of Jamaica and the University of Technology.
I believe that in discussing this provision with the ministry and the council, it was recommended that we remove 4B. 4B. And it was being suggested that the heads of departments and institutions should be charged with reporting rather than the individual teacher.
So then would it be to delete this or to just change it as to who should do the reporting?
We would leave A, so 4 would read, without limiting subsection 1, the council shall make it a condition of registration, a license or an authorization to teach, that if the person is charged with, well, it was being discussed as to whether we should say charged with or convicted or just convicted. If the person is charged with or convicted before a court of competent jurisdiction in Jamaica or elsewhere of an offense of a kind specified in the condition, the person shall within 14 days give a written notice of the charge or conviction to the council containing the details specified in the condition. Perhaps it would be more appropriate to say convicted, but we have to decide, the committee has to decide whether we want to put in those, you want to put in those words, charged with or convicted. So we'll just leave A and take out B and C.
So who would report? If it's not the person, who would report?
Well, as far as I can see here, the person is required to report. I'm not so sure if that responsibility would be taken away from the individual.
Well, I'm not understanding then, because in B, 4B, it said the person, if they're dismissed, they should report, but you're saying we're going to be deleting 4B? Members, any intervention here, especially or members with legal background? Looking at Member Green and others, yes. So, Ms. Sherlin, is it in 4B we're saying it should be the employer to give the notice rather than depending on the employee to give the notice if the person is dismissed?
Perhaps Dr. G should respond to this as to what is the appropriate thing to do.
The responsibility is on the employer to report. The employer, not the employee, the employer, because it was discussed, and what came out of the discussion is that the responsibility should not be on the person to report that he or she had been dismissed. It should be the employer.
So then why are we deleting 4B rather than just changing it from the person shall to the employer?
We would delete 4B.
Just some concern, through your chair. Charged versus convicted. And charge still maintain, Member Green, the presumption of innocence. And therefore, I don't know that we want to take that away, that presumption of innocence, by denying the person authorization. Equally, there may be some charges which really require interdiction, for example. So that is something that we need to consider, or we treat charges. But how will the employer necessarily know that up in Mavis Bank, or somebody committed an offense? You know, that didn't say Banbury, right? Somebody committed an offense. Or does that putting that onus on the employer? What is the mechanism for the employer to know? Or is it within 14 days of it coming to the employer's attention, which leave the gate open for the employer not having known? Or how do we address those issues?
Could it be the person or the employer?
So the challenge, Chair, or is it provisions of this nature, is you think of it twofold. One, yes, who will have the information that you're asking to be reported? And two, who can you take action against if they do not fulfill what is under the legislation? So I believe the section is framed in this manner to say that if you, Robert Miller, if you are a teacher and you are charged with an offense, then you have a responsibility to report that to the council, right? If you do not report it to the council and the council were to find out, then the council has the latitude under the act to take action against you, right? It's very hard to now say, for not reporting, right? It's very hard now to say that you would transfer that to the school, because if the school does not report, what sort of action would you take against the school, right? So I believe, especially considering that, as Member Brown said, if a person is charged, the school does not necessarily know, right? How would the school then report? So I'm treated with charge, and although I'm dealing with the charge, it stands, while the school would know if you have been dismissed for improper conduct and things of that nature, right? What you may want to do in those instances is have a dual reporting regime. because I still believe you may have a difficulty holding the schools to account, which is part of the challenge, which is a broader discussion, Minister, right? I take the point that the school would have the information if they've dismissed somebody, so you may be easier to get it from the school than the person who was dismissed. But if the person who was dismissed plans to go back in the classroom, then they would need to report. So you might want to, for the ones that deal with employment, indicate that both the school and the individual are to report, but you still have a challenge in terms of if the school doesn't report, then what? Clearly, if the individual doesn't report and you find out, then there's a difficulty. The other thing that we may have to consider, which was posited, I think, by one group, I can't remember which group, is whether somebody needs to report a charge for every offense, or you want to limit that requirement for them to report to certain offenses. Because as Member Brown has said, you also don't want to go too far in terms of reporting does not mean that there will be action. So I think we should make that point clear. And sometimes that is the issue. People believe that once you report, for example, that you have been in a physical altercation, that it will mean that it will have a detrimental impact on your license, which it shouldn't. But again, you may want to limit the offenses. And, you know, offenses are sectionalized. You may have the technical team, Minister, look at what offenses are most serious, what offenses in the context of taking care of children, what offenses, and say that if you are charged for any of these offenses, as opposed to if you're charged, for example, like indecent language, which unfortunately is still an offense. If you are charged for indecent language, would you need to report that? You know? So you may want to limit the offenses. We may want to limit the offenses that the requirement for reporting is.
But I hear you, Member Green, but what I'm still asking, I'm hearing from the legal team that they would delete 4B, which doesn't seem right to me. Why would you not require either the employer or the person to report? I don't know. Am I interpreting that correctly?
Thank you, Chair. Member Green, I'd just like to understand you better. Should we keep 4B and modify it according to your recommendation?
Well, probably I missed the reason why you were going to delete it. I never. Is there an indication that you are thinking of deleting 4B?
There was some discussion, but listening to you.
No, well, all right, let me say something, God. Clearly, I understood 4B to be put in because you have difficulty getting information, right? No, it may not necessarily be necessary if your licensing regime is effective and efficient. In other words, if once a teacher is dismissed from an institution, then that information automatically is passed to you, then you may not need to put in a legal provision for it. So, you know, it's really cheer for them. You see, I appreciate that what happens, unfortunately, in practice, as you are very aware of, Chair, is that because of maybe poor information systems, right? Member Miller might be teaching at Bridgeport High, and Member Miller is no longer there because of the school falling out of favor with him. And let me use that other way. Member Brown is at Bridgeport High. Yes. And Member Brown is no longer there because the school fell out of favor with him. And now he is going somewhere else to ply his trade. And the other school, unfortunately, does not know that member Brown was rejected from Bridgeport High. The real challenge, that's a real challenge in the system, it's a literal real challenge, and that's why we hear stories, unfortunately. Yeah. So that is so what this was trying to say is that if member Brown leaves Bridgeport under circumstances where he was dismissed, he has a responsibility to report to the council that he has had to leave. What a number of people are saying is that to give member Brown that responsibility, it might be foolhardy, because he would be reporting on himself in those circumstances. So the question is, can the information flow be achieved without having to legislate it?
Member Green, a recommendation from the Teachers Colleges of Jamaica is to add section 35, the following: no delay or failure to report under Section 4 shall bar the council from investigating any allegations of professional misconduct, and to take, now it just reads, no delay or failure to report under Section 4 shall bar the council from investigating any allegation of professional misconduct and to take in such disciplinary action against the offender. The council is obliged to ensure that any disciplinary action carried out in keeping with the rules of natural justice and not arbitrarily. And I think from the legal team it says we accept the proposal, except that we will indicate that the council can investigate and take such disciplinary action and not list what the investigation will be about. I don't know if that helps. But I understand what you're saying in terms of the flow of information, how difficult that is going to be. But that's one of the things we want to address in the profession, where you don't have a teacher resigning from one school under a cloud and shows up at another school with a squeaky clean, as if they have a squeaky clean record, and there's while obviously the school to which they're going should be inquiring of the school from which they're coming, but we know that sometimes that doesn't happen, right? It doesn't happen in all cases, and we have situations that people know of where the teacher has done something wrong at another school, and here they are over in yonder still teaching happily. So we want to ensure that we're dealing as best as we can with that situation in this bill.
So Minister, this speaks to dismissal, and you introduced resignation a while ago, two different things, but very important, because the separation from one school may be by resignation or it may be by dismissal. In this case, if it is by resignation, there's no reporting required. So maybe the technical people need to look at how we treat separation from one institution, whether by way of the principal by resigning, or the principal and the board first me by dismissing me. And also urge that we look, because we're talking about charge and conviction, we also look at the appellate process. How do we treat, if a teacher is appealing, for example, a dismissal, how do we treat that? And I have regard for the public services regulations, where it await the final outcome of these issues. So I want you to look, to you, Minister, look at how we construct this section, the need for reporting, whether the reporting come only from dismissal or separation in general, and as I say, the appellate process, is that allowed to work its way through?
So having read over the the suggestion by the teachers, colleges. It may be useful, Minister. I still have a challenge with putting in responsibilities where there are no sanctions. But it definitely stands to reason that it may be better that you have, in the instances where persons are separated from schools, whether through resignation or dismissal, in certain circumstances, that a report be filed with the council by the head of the educational institution, right? Clearly the challenge is that when you put it in, clearly it's legislation. The question is always, if they do not, then what, right? And maybe the team could give some thought to that. Maybe it can be dealt with here, you know, but that is my only misgiving. Again, I think the other suggestion about only relying on convictions, I think maybe going too far, right? Because I do believe that if a teacher is charged with certain offenses, yeah, there definitely has to be some reporting, because you definitely have to be aware and to determine whether there needs to be, you understand? Clearly, a charge and a conviction is very separate, right? But, you know, if a person is charged with sexual offenses in relation to a minor, right, especially in relation to a minor, you know, some questions will have to be answered in relation to whether that person should still continue while that charge is being fettered out. So I think having a reporting condition for the person in that regard, because they will be best placed with the information, we should maintain that. But if we're going to put, and then it gets a bit difficult in terms of how do you hold the head of the educational institution to account. And again, there may be a good rationale to incorporate, as suggested, 35, which is that section that says no delay or failure to report shall bar the council from investigating any allegation of professional misconduct and to taking such disciplinary action against the offender. Because oftentimes the information will come to the council, not necessarily from the head of the institution or from the teacher, but from other concerned teachers, parents, students. Oftentimes that is how the information will make its way. So you probably want to ensure that the council is clear with that power.
Chair, good morning still. Good afternoon.
Please go ahead.
Nadine Wilkins,
Yes.
Legal Reform. I'm just wondering if we're making an assumption that in all these situations, the head of the educational institution would necessarily be aware. A person could be charged with an offense and the head of the educational institution be wholly unaware. They may even be convicted and they're unaware. Because it may be something, you know, sometimes if an individual presents themselves to the court in a particular way, they may have a suspended sentence, they have been convicted, but they have not been incarcerated. Their sentence is suspended for a particular period of time, in which case their employer may not ever know that they have been convicted of this offense. And sometimes these offenses are sexual offenses. Just pointing that out.
Yeah, and just to, it couldn't apply for section 34A, 30 subsection 4A. It couldn't apply for that, because I agree with Ms. Wilkins. It couldn't apply in section, in where somebody is charged or convicted. I think we'd have to retain that, Minister, that it would be for the person, right? But in the other, in B and C, it may be better to merge them and say the head of the education institution. Because quite frankly, if somebody is dismissed from employment for unprofessional conduct or resigns for allegations of unprofessional conduct, then the head, if the head doesn't know. No, the head of the educational institution. The head of the educational institution.
That would be the board. That would be the board in our schools.
This is where education is very complex. Complex. I would take it that the head would be the principal of the institution, as opposed to the chairman of the board. But it's a very interesting argument as to, yeah.
I think in order to remedy that sort of situation, we just put the duty on the educational institution instead of stating the head of the educational institution. So whether it's going to be coming from the board under the chairman or the principal.
And who we penalize for the educational institution?
Well, that is an issue we also had in relation to the fines itself, whether to fine the employer for employing someone without a license or an authorization to teach. So that is something we would need to look into as well in terms of penalizing the employer.
I propose through your chair that this section needs a little more working through, and the technical people probably should do that in light of the comments made today and come back to us.
Minister,
So
if
kind
I,
of all of section 30.
sorry,
Oh,
if I may, Minister, thank you. Member Green made reference to the fact that perhaps in relation to 4A, we should specify the offenses. Early draft of the bill, we had specified a number of offenses, and it was found that it was very difficult to specify because there was the risk of leaving out certain offenses. I don't know if you want us to go back to that and to try again to specify, because there are a number of offenses in the anti-gang legislation, for example, that could guide us. And we already have a list that we had taken out from an earlier draft. So would the committee advise us to go back to that list or to try to refine that list and for the committee to examine such a list?
Yeah, I would suggest you bring it. Bring the list, let's look at it. But I do take the point. It's very difficult because in putting some in, it means you're leaving some out, right? And because you're dealing with children, it's difficult. But there's also a balance in terms of, again, if you're charged with malicious destruction of property, should you have a reporting? It's tough. But I would say bring a list. Clearly, I think there are some offenses that stand out, but clearly there are also some offenses that are important that might not cross our mind. So I understand. Bring it. Let's look at it when we're looking back at the section. And Chair, if that's fine.
that's fine. Okay.
Chair?
Yes,
please.
go ahead, Dr. Gordon.
Because of that very dialogue, we had agreed to define this qualifying offense. Means an offense for which the penalty is a term of imprisonment of 2 years or more.
All right, so as one member recommended that that the legal team comes with the list that they were looking at the last time, so we can have sight of that and help to determine if that should be included or we can leave it the way it is. But I know we're asking for a relook, a reread, a reconsideration of Section 30, paying special attention to 4, subsection 4. All right.
Chair, that would include the issue of appeals following convictions, or an appeal to the teachers' council, to the, what do you call the teachers' council?
The teachers' appeal.
No, the teachers' appeal tribunal,
yeah, tribunal,
yes.
yeah. All right, we will move on to section 32, review of condition by council. One recommendation there from the Jamaica Teachers Association, where it says section 32(3) makes no reference of an information notice being delivered when there is a cancellation of conditions. And the response is that the information notice to be sent in all instances. 32(2)A to D. So is there a change that's going to be made in there to make that explicit? Will there be a change to include that an information notice is to be delivered?
Yes, Minister. The suggestion was for it to be amended to indicate that it's for all 4 instances.
All right, thank you.
And that would be captured in the regulations as well, as the form of notice, etc.
Mr. Brown, could you, sorry, I might have missed what you just said. What was it that you wanted with regards to this section?
The issue of the notice of information notice would have to also appear in the regulations.
Okay.
So,
making note of that, legal counsel. All right, thank you. We will move on now to, is that part 6? Section 35, application for registration as a teacher. And we have the Ecumenical Education Committee and the Jamaica Council of Churches. Their recommendation is that section 35 to 38 deal with these applications for registration, licensing, and authority to teach. Contents normally in regulation. It is being recommended to give regulations high priority. And the response is that the regulations are being given high priority. Anything else you want to add to that from the legal team? With 35 to 38.
Chair, just that high priority thing, maybe Dr. Gordon can tell us how you intend to deal. First, we deem everybody to be licensed when the bill is passed. But what's the plans going forward? All those who are now in the profession would be deemed to be in the first go around to be licensed. No? Registered. registered. But what's the logistics for registering going forward so that when we say in response, high priority, we know that we're not going to get into a bureaucratic thing, delay, and all that. I just would love a sense of what's the plans, what are the plans?
Registration is already on the law books from 1965. So teachers are required to register. In fact, the statement says a teacher shall not teach in our schools unless the teacher is registered as a trained teacher, pre-trained teacher. That's now in the present law. So in the council, there's a unit that deals with the registration of teachers. As we speak, the registration database has nearly 30,000 teachers, which tells you that some retired teachers and some private teachers are still on the register. So we have a register of teachers. There might be a few teachers who have not been registered, and really very few, because at the point of graduation from college, the emerging candidates are encouraged to go and register. Now, the licensing, we will have to phase that in because we don't want all our teachers to be licensed at the same time. So that has to be phased in over time. We have had discussions with the electoral office because they have been engaged in such processes.
All right, Member Brown, are you okay with that answer?
Yeah, I understand.
All right. Moving on to the Teachers Colleges of Jamaica, their recommendation is that Section 35 2B be amended and to remove the following words from Section 35 2B in the case of a person who intends to teach in an early childhood institution. Should I read the rationale? All right, it says this will allow for criminal background checks to be conducted on all applicants. This will give all members of our society the assurance that persons will not be employed at any level of the education system whose antecedents suggest a propensity to do harm to others, students, fellow teachers, staff, parents, guardians, or other visitors to our schools. With the proposed expanded use of criminal background reports, we can learn from the experience of the Early Childhood Commission, which is the only entity within the education sector requiring police records of all staff at school. ECC was criticized in the Patterson report for having altered the validity of police records to suit the 5-year license period of teaching licenses. Our recommendation is that a current valid police report be provided in support of each application for registration, licensing, and authorization. And the response from the legal team says to include new 35(2)(c) to cater for other institutions. Consider the language used at 36(2)(b)(2). Mandatory requirement for all institutions will have a financial implication. Can you explain, legal team, please?
Chair, the thinking behind including a new 35(2)(c to cater for other institutions in relation to getting a consent to do the criminal record check. So 36(2)(b)(2) reads, subject, it says an application under subsection 1, which in this case would be in terms of, right, so we indicated that we would use a language that is similar to section 36(2)(b)(2), which indicates that a consent by the applicant for the council to conduct a criminal record check if the application is granted on the licensed teacher where the council has reason to believe that the applicant or the licensed teacher, as the case may be, is not fit and proper person to teach. So it would not be in all instances. It would be in a case where the council has reason to believe that the person is not fit and proper to teach, based on the financial burden that would be undertaken if we required for all applicants. That was the thinking.
If a consent is given, consent form is signed, who pays? The council or the person being researched?
You know, Chair, I know some of these discussions are difficult, but let's you know, as it is now, our early childhood practitioners have to have a police record. There is no if or but, and unfortunately, they still remain at a low level on the remuneration scale. But the concept of their level of remuneration is not contemplated, because in order to interact with the children, you have to show that you do not have any criminal record. This should be the case all across the system. This should be the case all across the system. There is no reason why we are saying that we need to know if you're going into the classroom with our most minor children, if you have a criminal record, but if you're teaching high schoolers, we don't need to know. And we can't have it, in my view, both ways, right? I believe it would be very subjective if you come to me and say to me that you deem me not to be fit and proper, so then I must go and get a police record, when I have said to you I believe I'm fit and proper, right? And we would have to be in a back and forth as to why you deem me not fit and proper to cause me to have to go to get a police record, as opposed to saying that once you are looking to enter the teaching profession, then you have to get a police record. What I would suggest, Chair, is that all our teachers who are presently in the system, that would not be a requirement for them, because when the bill comes in, they'll be shepherded in. But everybody knew who is coming under this bill. It should be a requirement that you have a police record as a document that goes with your application for a license. You know, again, we have to look at what are we trying to achieve, and we are clearly trying to ensure that the people who enter in upon our classrooms are fit and proper. and you should need a police record for license to teach. As if you're going to get an authorization to teach, it should be standard. And if it was standard, if you're going to join the police force, you have to come with a police record. If you're going to go on the farm road program, you have to have a police record. So to travel on the farm road work is more critical than to go in the... No. No. You have to have a police record. It's just because we've never put it in place. But we have to start afresh with this bill. That is my position.
Agreed, Member Green. I totally agree. Yep.
I'm not sure I'm there yet, but I just want to make it clear. I'm reserved on that one. I'm there about a police record for every teacher.
And if I may, Madam Chair, I think the member will reach there soon, but I'm in full agreement for that. If someone is going to teach our students or children, we want to ensure that they are safe in that person's care, and we want to ensure that a record is presented when that person is entering. As my member Green stated, that those persons who are already in the system because of the act just coming in will be ushered in. I'm in full agreement, but even for renewal, you know, that could be presented as well. But I'm in full agreement that every teacher should possess a police record.
And Chair, I'll make this point because I know that this was one of the issues which we had moved to resolve, and I see that, you know, I think his Patterson report may have taken issue. But I support the move that was made at the time, and I would support it for this. The requirement is upon application and upon renewal. In other words, yes, a police record is only valid for a specific period of time, but it wouldn't be that once you've applied and got your license, that each year you would need to refresh the police record. What used to happen in early childhood sector is that there was a call for them to put a new police record on file each time one expires. Now that is costly and that is unnecessary, especially in circumstances that nothing has come to your attention that signals that the person has behaved in an untoward fashion. Especially with our reporting conditions in this act, you would only need it when you're applying, and then at the end of that tenure, that term for the license or the authorization when you're reapplying. That is what I would suggest. So it's not now in there, but I really would strongly suggest that we move in that direction.
Members, I know that there is another meeting to be held here at 1 o'clock. I'm suggesting that we stop here and then we'll pick up next time we meet with our legal team. There's a lot that we have asked you to take a look at again to come back to us on. And once that's done, we would pick up at section 36 and move on from there. But we'd love to get the outstanding matters resolved before we move on much further. All right? All right. Is there any other business?
There was an effort to get a date, 20th or thereabout. Was it that?
The dates?
Yeah.
All right. The proposed next meeting date will be Thursday, October 20 at 10 a.m. And then beyond that, future hybrid meeting, please pencil in Tuesday, October 25, 2022 at 10 a.m. as well. So this will give our legal team quite a bit of time between now and the 20th to come to do the review and to come back to us with all the sections that we've queried. All right? All right, we're at the point of adjournment. So moved by Member Miller, seconded. Member Brown, thank you. Thank you, members.
Something is happening for someone in this country every single day as a result of the actions of this government. The benefit